You just got served with a lawsuit. Your name is on the paperwork, not as someone suing, but as someone being sued. And the reason? You're a trustee. I'm Ben Fox, a California trust and estate litigation attorney at Fox Law. And if that's your situation right now, I want you to take a breath, because being named in a trust lawsuit does not automatically mean you did something wrong. But it does mean you need to understand what you're up against, and fast. Trust litigation is more common than most people expect. And trustees are natural targets because they sit right in the crosshairs of competing interests: the beneficiaries, the trust itself, and sometimes other co-trustees. The most common reasons I see trustees get sued come down to a handful of issues. Alleged breach of fiduciary duty, meaning someone claims you didn't act in the beneficiary's best interests. Failure to account. California law requires trustees to keep beneficiaries informed and to provide formal accountings. A lot of trustees either don't know this or they don't put enough effort into getting it completed. Third, self-dealing. This is where you as an individual enter into a transaction with you as a trustee. Imagine you want to purchase a house from the trust, but you're the trustee. Entering into a transaction with the trust, even with good intentions, can trigger a lawsuit. And finally, sometimes it's not about what you did at all. The issue could be a dispute over how the trust document should be interpreted, and you're caught in the crossfire. Are you personally on the hook as a trustee? That is a question I hear a lot, and the most honest answer is, well, it depends. As a trustee, you generally act in a representative capacity on behalf of the trust, not as an individual. In many cases, that means a judgment gets satisfied from the trust assets, not your own bank account. But that protection has limits. If a court finds you committed a breach of duty, especially if it involved bad faith, fraud, or self-dealing, you can be held personally liable to make the trust whole. On the other hand, if you acted in good faith, followed the terms of the trust, and kept proper records, you may also be entitled to have the trust reimburse your legal fees. So protecting yourself legally now can matter a great deal financially down the road. If you've just been served, here's what I need you to do immediately. First, do not ignore the paperwork. Missing a legal deadline can result in a default judgment against you, even if your defense is strong. Second, preserve everything. Do not delete emails, financial records, or any documentation related to the trust. You have a legal obligation to preserve evidence once litigation is in play. Third, stop making unilateral decisions about the trust. Major distributions or asset moves during active litigation can seriously deepen your exposure. Get legal advice before making a substantial decision about trust assets. And fourth, when the other side has an attorney, I do not recommend you try to work it out with the other side without your own legal representation. Even a well-meaning conversation can be used against you. Being sued is not the same as losing. Trustees often have powerful defenses available to them. If you follow the trust document in good faith, California courts are generally reluctant to second-guess your decisions, even if the outcome wasn't what beneficiaries had hoped for. If a beneficiary previously approved or knew about the conduct they're now challenging, that consent can be a meaningful defense. And California law imposes strict time limits on trust claims. If a beneficiary waited too long to sue, particularly after receiving a formal accounting or notice, their claims may be time-barred entirely. The key is having an attorney who knows how to identify and assert those defenses before the window closes. Trust disputes in California are typically heard in the probate court, which has its own procedures and timelines. After pleadings are filed, you'll go through discovery, which is an exchange of documents and information, and sometimes depositions. Many cases settle through mediation before ever reaching a trial. But if the case goes to a trial, it's decided by a judge, not a jury. Every stage of the process goes better when you have experienced counsel from the very beginning. Trust litigation is a specialized area of California law. The decisions you make in the first days and weeks after being served can significantly affect where this ends up. At Fox Law, we represent trustees, beneficiaries, and other parties in complex trust disputes throughout California. We understand the pressures you're facing, and we know how to build a strong defense. If you've been named in a trust lawsuit, or if you think litigation may be coming, contact Fox Law today to schedule your initial no-cost consultation at foxtrustlaw.com. The sooner you reach out, the more we can do to protect you. Thanks for watching.